Hello and welcome to 60 Seconds with Sergio. I am your host, Sergio Cabanas, attorney at law here in Florida. Thank you for joining me today. Today's question is, Sergio, it appears that my spouse and I are about to go through a divorce, or we're already going through a divorce as we speak. Now, my spouse and I have acquired several assets during the marriage, and I understand that it all is going to be divided by a court in the event of a divorce. But could you explain a little more how the court goes about dividing these assets between the spouses during a divorce process? Well, this is a complicated area of the law, and I'll do the best I can to summarize in this video to at least give you an idea of the general principles. Generally, under Florida law, the courts would look at any and all assets that were acquired during the marriage and take those assets and divide them between the spouses in equal parts to the extent humanly possible. So that means if there's a bank account that contains $10,000 that was acquired during the marriage, the court will normally divide those assets in equal parts, giving each spouse $5,000. Similarly, in those cases where the asset's a little harder to divide, such as land, what the court will do is order the sale of the property and divide the net proceeds of the sale between the spouses. There are three basic exceptions. Exception number one of the spouses acquires an asset through an inheritance. Then that's considered to be non-marital. Exception number two, one of the spouses acquires an asset through a gift that he or she receives as an individual. Exception number three is any and all assets that were acquired prior to the marriage. Keep in mind that we're talking about the law, and there are exceptions to the exceptions. And here's a big exception to the exception, and that is any asset that's otherwise considered to be non-marital is ever commingled with any marital assets, then it may lose its non-marital status and become subject to a distribution in equal parts in the event of a divorce. Let's suppose that you received an inheritance of $50,000. You then deposit these funds into a separate bank account under your name only. We're doing good so far. However, during the marriage, you commingled marital assets in with that bank account. Well, by doing that, you may have contaminated the non-marital asset with marital assets, making the whole thing subject to equitable distribution in a divorce proceeding. So basically, even if you deposit some money that's marital into a non-marital account, you may have now made the entire account marital and subject to a divorce proceeding. Similarly, if you had some type of real estate or some land or other property and you transferred title from your name only to you and your spouse, that's essentially commingling the non-marital asset with the marriage, making the whole thing marital. If you find yourself in this situation, it's important to consult with a knowledgeable attorney who can review the circumstances of your case and figure out whether we can still salvage the situation, perhaps through, for example, a postnuptial agreement. Again, I hope this short video provided you at least some idea of how the laws work in this very complicated area of the law. Thank you again for joining me today, and as always, stay informed so you can stay strong.